Hi everyone, Layla Benampour here. Thank you so much for joining us today. I think this is going to be a really interesting CLE. And as Kyle said, we're combining the natural resources section and the real estate section. So our presenters today will be Jeff Kahn from Lyons Gaddis and Kara Godbehere, also from Lyons Gaddis. Jeff has been practicing law since 1975 and started doing water in 1980 at the AG's office. He's been with Lyons Gaddis and predecessor firms since 1980. Jeff is a well-known water lawyer. He represents clients in water court and water-related transactions. His clients include municipal water providers, special districts, water conservancy districts, ditch and reservoir companies, and developers. Kara has been practicing law since 2005, and she is also at the firm Lyons Gaddis. She assists buyers and sellers and real estate brokers in completing due diligence and verifying title to water, mineral, and other property rights, and also ensuring that these rights are properly conveyed. She's worked with a wide variety of clients around the state on water and property transactions and litigation. And her initial interest in water law was from the agricultural perspective, and her family still farms in northern Oklahoma. So I don't know, Chad, if you wanted to introduce yourself or say anything else, but otherwise we can get started.
Great. Yeah, I don't have too much to add, Layla. I'm Chad Cooper. I'm the chair of the real estate section, and excited for the presentation today.
Thanks.
So I'll get started. I'm going to do share screen here. Let's go here and then share. Okay, everybody should see the opening slide. I'm going to go first. Kara is going to follow. When I looked at the attendance list, talked to Kyle last week, it appeared that there were about 1/2 real estate lawyers and 1/2 water lawyers in the audience today. My presentation is going to be geared primarily to the non-water lawyers, the first half. Basically, I'm going to give a primer on what types of water rights and other water interests may be transferred as part of a real estate transaction. How to identify what type of water right is supposed to be transferred, or whether it's in fact not a water right, but just an interest in some other water asset. It has got to be the first step in a diligence investigation. You cannot get started in a diligence investigation until you've identified the nature of the water asset that is supposed to be transferred with the ground. Kara's presentation is more geared to the water lawyers in the audience, more of the nitty-gritty, the detail of a diligence investigation. As is usual, I think Kara's going to do more of the heavy lifting. To some extent, the water lawyers may not learn much from what I'm going to say, but you'll still get CLE credit for the whole hour. I'm not trying to teach a water law class, just enough to get started in diligence to see what water you're going to get. Please save questions to the end. As Kyle said, we'll try to save 5 to 10 minutes. I'm going to try to go fairly fast to save the appropriate time for Kara. You are presented or drafting a real estate transaction. First, look and see if water rights are identified in the MLS listing. The lower left blocks and lower right blocks refer to water rights. If the contract is already drafted, look at section 2.7 of the standard land contract. Look at the other documents. Are water rights identified? Review the disclosure documents. If water's not disclosed there, ask the principals, is the property irrigated? If the answer is yes to any of the above, what water rights are identified, or what is the source of water used on the property? What is the source of the irrigation property? If you see what I would refer to as a direct flow water right, like the John Smith ditch, and there's no storage involved, then you've got a water right that's supposed to be used on a direct basis. It's delivered and it is put to beneficial use. You are allowed by a statewide rule to store for 72 hours in any event. These types of water rights are not shares in a mutual irrigation company. We'll get to that later. Rather, you have direct ownership. First, make sure it is in fact adjudicated. The statutory references there, and we'll distribute this PowerPoint after the program, Kyle will, are to the definition of tributary water and what a water right is. How much of the water right is identified? Are you getting 100% of the water right or less? If you're less, who are the co-tenants? How is the water delivered? Do you need an easement across third-party land? Is it deeded, a written, recorded easement, or is it prescriptive? You need to find out how maintenance and operation of the ditch is conducted. Is there a written agreement between the co-tenants, which I would regard as unusual, or is it informal, which is more to the point? Always check the abandonment lists with any water rights. I had an experience recently where I was actually representing a seller. In the listing, they had identified a water right. When I looked at the abandonment list, I found it was abandoned. You don't want to buy or sell an abandoned water right. Is it necessary to do title research? It is always potentially necessary, and Kara will cover that in a fair amount of detail. I want to emphasize again, get the decree. I've had transactions where it was purported there was a decreed water right, and when we looked, we found it wasn't decreed, much to the surprise of the seller. You may also then see, or in the alternative, you're going to get a storage water right. Example, in the documents, John Smith Reservoir is identified. Same inquiry, are you getting 100% or just a partial interest? Who are the co-tenants? Get the water right, confirm it is in fact an adjudicated water right. It needs to say it's a storage water right in the decree, and you can store for longer than 72 hours. Some water rights you can store in a reservoir don't need to be decreed. CBT water, non-tributary and not non-tributary water, for example, but then you're not going to get a water storage right. If you're getting a water storage right, you need to find out how it's delivered. Do you need a carriage contract with facilities owned by third parties? Is that contract historically informal, unwritten? That's probably more the rule. But if it is across third-party lands, find out, talk to the third parties, make sure that they're not going to, after purchase, say, sorry, we don't believe you have an easement. If you're getting a partial interest, again, operation and maintenance, particularly crucial for a reservoir as pertains to the dam and spillway, which can be expensive. If you are buying an interest, either 100% or partial in a reservoir, you need to know if it's jurisdictional or not. Jurisdictional just means the state engineer does dam safety inspections. I'll quickly give you the rule, but you really need to get a water loss specialist involved then. If a dam is more than 10 feet high, the water depth is more than 10 feet, or the reservoir stores more than 100 acre-foot, it's going to be jurisdictional. You want to get the reports. Your potential maintenance and repair expenses are higher. And again, check the abandonment list, make sure the storage right has not been abandoned. Third category, and I'm going to go over 10. The ones that follow are going to be shorter because they're less frequent. Are mutual irrigation company shares. Example, John Smith Ditch Company. First thing, confirm that the company is in fact incorporated on the Secretary of State website. In Boulder County, there was this Weck and Turner Ditch Company, which always acted like a ditch company, but was not incorporated until 2013. Statutory reference there is to the sections dealing with mutual irrigation company. One of the first questions is confirm that the seller has the original certificate. I would say probably in close to half the transactions, the seller turns out never got the original certificate or lost it. There are statutory procedures to replace it. You would like to get a certificate at closing. Review the articles, bylaws, rules, regulations, and policies of the company. There are frequently surprises there, including you might see a first right of refusal that goes to the company and or the shareholders in the company. There may be a bylaw requirement if you want to do a change of water right. It is now common that there's what is known as the Catlin provision in the bylaws that requires company approval of any application to change the water right before you can file in water court. Kara may get into a little more detail on that, but at least you want to know it's there. And are there restrictions on place and type of use? There are some companies that the bylaws restrict the use to irrigation and irrigation under the ditch. I won't get into the legality of that. I've actually drafted some of those, but you need to know if it's there. And is title research into the company records necessary? Kara's going to get into that in more detail. You may want to look and see if the company's got a website and talk to the company secretary about assessments, make sure they're up to date, and similar questions. You may have a groundwater right or a well identified, frequently identified by the permit number. You want to obtain the well permit or registration. You want to figure out if the well is exempt from administration. That is important because if it's exempt, you get to operate it all the time without augmentation. It's operated outside of the priority system. The permitted uses are frequently going to be either inside use only or inside use plus up to 1 acre of outside irrigation, but limited use. Is the well drilled and producing? Are you getting a well or a spring? If you think it's a spring, you may want to try to convert it to a well, as it may be then exempt from administration. Springs, if they're considered surface water, are never exempt from administration, so technically you can get curtailed. Again, if it's a non-exempt well, then almost always it needs to be augmented under a replacement plan to be operated. You need to get a specialist involved. Check and see if it's decreed. Not necessary that it's decreed, but if it's decreed, you may want to look, you do want to obtain the decree, review it. the permit may not say it's exempt, but the decree may. Find out about the yield and condition of the well. Next category is non-tributary groundwater, sometimes known as deep aquifer water, or a well that's permitted pursuant to Senate Bill 5. In this area, this is in the Denver Basin. The aquifer may be identified in some of the documents. It's going to be the Denver, Dawson, Arapahoe, or Laramie, Fox Hills aquifers. These are generally at least 500 feet, if not deeper, into bedrock formations. The definition is cited there of non-tributary groundwater. You may also see not non-tributary groundwater. Only in water law would we have a contradiction in the very definition. That just means it's actually tributary water in the Denver Basin, but it's allocated to the landowner. You will have a replacement obligation there. Probably you need a specialist if you're getting that and you want to have all the rules explained. 379137 addresses permitting of non-tributary groundwater. You will likely, if it's identified there's already a permit issued, review it. You can find it on the state database. Check and see if there's something which may be labeled as a decree issued for the non-tributary groundwater under the land that you're acquiring. Technically, the decree does not grant a water right because it's non-tributary groundwater, and not tributary groundwater and decrees are only granted for tributary groundwater. But the decree confirms the right to withdraw and sets the parameters, how much can be withdrawn and from what aquifer. You may want to find out if there's any documents available addressing the water quality, particularly in Laramie, Fox Hills. Water quality is questionable. And same inquiries as to the yielding condition of the well. Even more important with these wells because they're deeper, more expensive to maintain and repair or replace. You may see that you are getting a well permit in a designated groundwater basin. These are generally in eastern and southern Colorado. There is not a designated groundwater basin in Boulder County. These are basins where groundwater is the dominant source of water as opposed to surface streams, although occasionally you'll see a surface water right in a designated groundwater basin. In a designated groundwater basin, the management district controls, and the groundwater commissioner controls the administration, not the state engineer. And the permits are issued by the groundwater commission. If a permit is conveyed, same, you need to review the permit. Hopefully it's a final permit. The regulatory scheme is complicated. And if you need to change the permit, you probably need to get a specialist involved. It is possible, but it is, I will tell you, it is beyond my expertise. You may see in the contract that CBT units are identified. If you're acquiring some rejoice, they are scarce and very valuable. You need to make sure you're getting the base water supply on the ground you're acquiring, along with the CBT units, because Northern, when they transfer the allotment contract to your name will do a check and make sure you've got a base water supply, native water, shares in a mutual irrigation company or direct flow or storage right or augmented groundwater well. Without that, you cannot be assigned the allotment contract. If you're selling, but the intent is to retain CBT units, you need to remove them before closing. Otherwise, it will be assumed they're transferred with the ground. And if your intent is to retain, you don't want to see that have that happen. You may see that a carrier ditch or lateral ditch is involved. I'm going to be very quick on the first category, carrier ditch companies. They're very unusual, but there are some. For instance, if you see you're getting church ditch inches, you are really getting a contract from the carrier ditch for delivery of water. They're very unusual, but there are some. More frequently, you're getting shares in a lateral company that provides a link between the main ditch and your ground and may be incorporated, and you need shares. For example, if you're getting left-hand ditch company shares as part of a transaction, you need to make sure you're getting shares in the appropriate carrier ditch. For instance, and some of you may have run into this, Williamson, Holland, North Tollgate, Haldye. There's 10 to 15 carrier ditches, and you not only need the left-hand ditch company shares, which holds the water rights, you need shares in the carrier ditch to assure delivery to your property. If you're not getting shares in the carrier ditch, for instance, you're getting left-hand ditch company shares or other shares or water rights where there's a lateral ditch company, an incorporated ditch company between the main ditch and your property. You need to find out how your predecessor, the seller, got delivery and make sure you're going to get delivery. In some instances, you may see that there's a contract water right identified. Frequently inches in a ditch company, or it may just say certain contract rights. These are very old contracts that the mutual irrigation company issued in exchange for a right-of-way, generally to landowners at the head or beginning of the ditch. The landowners, for whatever reason, did not want to join the company and become shareholders, so they traded a right-of-way for a contract right for delivery of water. In Boulder County, we run into these. The Leggett Ditch issued contract rights. The Lower Boulder Company issued contract rights. Find the contract. If you think you're getting one of these, read it. Find out what the limitations are. Frequently, there's a limitation on use only for irrigation, a limit on the lands that may be irrigated, which are those that were owned by the original grantee of the contract, and be advised that the company will always try to negate or limit delivery, because the holders of these contracts are not shareholders and do not pay assessments. Last slide. If no water rights are identified in the contract or on the MLS listing or in the disclosure documents, that does not necessarily end your investigation, particularly if the property is irrigated. Want to find out what the source is of the irrigation water, and see if the intent is to have those transferred. If it is, then add those to the contract. If you're aware that there's non-tributary groundwater underneath the land, find out if the intent is to exclude those water rights. They can be excluded, but only if they're specifically excluded. My advice is don't leave it up in the air because you're going to get into a dispute. That's it with my presentation. I think there are 30 minutes left. I'll turn it over to Kara, and at the end, we'll answer questions that either come orally or in the chat box. Thank you. Let me end share screen here. Kara, you should be able to share screen now.
Yeah, let me try. Let's see. Okay, just make sure I have the right screen showing. So we want screen 2. Okay, can everyone see the main page?
It looks good.
Yes, looks good.
Great, thank you. Okay, so as Layla said, I started my career in water law. I've always practiced water law on my family farms, so that was my initial interest. I'm going to be talking today about some concerns or considerations for conveyance of water rights. I'm going to start with a few, my screen looks kind of strange. Okay, I'm going to start with a few important considerations under Colorado water law that might impact buying or selling water rights. On the slide you see the ownership of land adjacent to water does not necessarily give a right to use that water. Colorado is a prior appropriation state, not a riparian state. In a riparian state, ownership of waterfront property gives you a right to use that water. That's not true in Colorado. If you have a stream running through your property, that does not necessarily mean you have a right to use any of the water in that stream whatsoever. In Colorado, a water right is considered a vested real property right. Water rights are not permanently tied to any specific land, but can be sold for use on other properties, sometimes many miles away, and I'll talk about that a little bit more in a few minutes. Water rights transfers are subject to the same formal requirements as other forms of real property, with the exception of ditch shares. So with water rights generally, they should be conveyed by deed and recorded with the county, with one very important statutory exception that I will cover in just a second, which is shares in a ditch company. So we have a statutory requirement in Colorado for conveyance of water rights, as some of you probably already know. A water right is a conveyance in real property and generally is conveyed in the same manner as real property under CRS 38-30-102, which says, in the conveyance of water rights in all cases, except where the ownership of stock in ditch companies or other companies constitutes the ownership of a water right, the same formality shall be observed and complied with as in the conveyance of real estate. So keep in mind, though, that water rights, because water rights can be conveyed separately from the land where the water is used, and there's no requirement that conveyances be recorded at all if the water is stock in a mutual ditch company. So what that means in real life is that we often have very inconsistent records of ownership for ditch shares specifically, because there is no requirement that they be evidenced really by any documentation other than that required by the ditch company itself, in order for the shareholder to receive delivery of the water. And ditch company documents are not usually available to the general public. Just like any other corporation, they're usually only available to shareholders. So for water attorneys and real estate attorneys specifically, one of the frustrating things I run into often is that there really is no central database or clearinghouse or a singular place you can go to look up ownership of ditch rights really. as a member of the public. And even as a representative of a buyer or seller with a signed contract in hand, different ditch companies have different policies as to what they will share with people who are not shareholders in the company. So sometimes it's hard to get information on the shares, ditch company shares that may be listed in a contract for sale. Another thing to keep in mind throughout this discussion is that most ditch companies are volunteer operations. Often there will be a couple of officers that are shareholders in the company. They may have 1 or 2 paid employees, if any. And so sometimes it's hard to get access to the records. There can be some delay. Sometimes you're going to someone's house and looking through a cardboard box in their basement. I've been all over the state and I've looked at all sorts of ditch company records and I've met people in coffee shops. I think often when we consider stock certificates, we think of something more corporate where we're going to be going downtown and sitting in an office and somebody's going to be bringing us a file box. And that is not usually the case with ditch companies. So this type of inconsistent record keeping is challenging and creates some issues because it can create severance concerns. If you remember on one of the first slides, I said, it's possible to sever water from the land where it's been historically used. With this type of inconsistent record keeping, that can make this kind of issue more likely. It's also possible to change water for use from one location, where the original irrigation use occurred, to a different use or different location many miles away. And I have an illustration up here on the screen of Aurora's Prairie Waters Project. This is a good example. There are, I want to say, 23 wells up near Brighton that are pulling water out and then piping it all the way back to Aurora. So we're going from the very far northern end of the metro area down to the southern end. And all of the original water rights changed for use in the Prairie Waters Project probably came from farms all over the metro area. So this is where it becomes important to know, have consistent record keeping and investigate title and make sure you have a good understanding of where the water was historically used and where it's allowed to be used now. Let's see. Oh, another really important point here that most of you are probably already aware of: title insurance companies do not insure water rights. They're almost always listed as an exception. I have never seen a title policy that covers the water rights involved in a transaction. And what that means is that, the deeds, even the conveyancing deeds, often are not as clear as they could be. Because there is no requirement by the title company that, the water rights be listed in some specific way or the deed be done in some specific way. So sometimes you end up with deeds in, if you're looking at a chain of title, sometimes you end up having deeds that have very specific language, with a stock certificate number and a precise amount and a historical irrigated acreage location. But then the next deed in the chain may not say anything at all. Or it may say something very vague like any and all water rights. So it's just difficult sometimes, even when you're doing title investigations, to know what you're getting based on the language contained in a typical real estate deed. And then fourth concern is that often the documentation, the deeds themselves and the recording can be pretty sloppy. And I will give a good example of that in just a second. These are all publicly available documents, so I'm not sharing any privileged information, but this is a real Excel spreadsheet that I created to try to track some water rights that were being purchased. And if you look at I don't know how well this shows up on, hopefully you guys can see this. This is a good example of sloppy recording and conveyancing because the numbers don't add up. We start, let's see, over here with Ellen Wilkinson. She has 3.5 inches of what we call transfer water from this part of the Durans, but we don't really know what transfer water means. It's not described in the deed at all. And then we have a conveyance from the city of Arvada to Ellen for 3 3/4 inches of Swadley, and that deed was never recorded. I can't even remember how we ended up finding that deed, but it was missing. And I think somehow we went through either, it was either Ellen's chain of title or the city of Arvada's chain of title. Somebody was able to provide us with this unrecorded deed. So if you look up in the upper right-hand corner of your screen, we have Arvada selling Ellen 3 3/4 inches of Swadley. And then there's another unrecorded deed in this chain from Arvada to Ellen for 3 3/4 inches of Swadley traded for Yoakum water. But there's no way to definitely say that the 3.5 inches she got from the Durans on the left-hand side of the page was traded for 3 3/4 inches on the right side. So we already have this confusion as to what these water rights are. And then we have this guy Martin showing up in the chain that I assume is her husband. I never did confirm that. But his conveyance numbers don't match up with Swadley or Yoakum. Over on the left-hand side, we have 3.5 inches going to Ellen. On the right, we have some sort of trade with Arvada. And then down at the bottom, suddenly we have this guy Martin conveying 3 1/4, which doesn't match either of the previous numbers we have. And then to complicate all of this, I was never able to find any sort of record of Ellen's death, or, sometimes I'll be able to find, a death certificate or a marriage certificate, so I can confirm Martin was even related to Ellen or had some authority to convey this water on behalf of her estate. Wasn't able to find any of that at all. So, sometimes it's a little bit like putting a historical puzzle together. And this example that's on the screen right now isn't even unusual. I would say it's more common than not. Say it's actually pretty rare to find a clean, smooth, easy chain of title for water rights. And you're often trying to piece together the relationships between the parties and make assumptions about what their intent was. As far as the transactions, when you're doing the title work for water rights to be conveyed in a transaction you are working on. So let's talk about due diligence for water rights and the goals for that. And that's just making sure the water being conveyed is what it is purported to be and is owned by the person claiming to be the owner. Historical consumptive use investigation. This is important if the goal is to eventually change the water rights for a different use. So maybe not always a concern for individual buyers, but more common with commercial or municipal purchases. This type of analysis is usually done by an engineer. I have seen other types of scientists do this, but they are most often engineers doing the historical consumptive use work. And the reason you would do an analysis like this is for a change of water rights case, or if you're trying to get an estimate of value, the value of the water that could potentially be changed in the future. You need to know, in Colorado specifically, our water rights are based on the amount used. Your water right, the cap on your water right is the amount actually consumed by whatever the decreed use is. So to do a change of water rights case or to estimate value of a water right, you need to know how much water was actually used by the decreed owner, as in consumed by the crops and actually lost from the stream versus lost to evaporation or runoff returning through the soil and going back to the stream. You want to know what was actually consumed. Title investigation is often done by an attorney. And we are looking for marketable title because remember, there's no title insurance. Marketable title just means title that a reasonable person would accept. We want to look at historical use often, especially for if we want to know what the historical consumptive use was. This can require looking at aerial photography of the farm where the water was used. Interviews with farmers and farm workers or family members. You'll see affidavits sometimes signed by, tenant farmers or the original farmers that use the water rights. I've looked at Farm Service Agency crop records to see what type of crops were grown on the property. Different crops consume different amounts of water, different times a year. And then matters outside the record. These are things that may not be apparent through, looking at the recorded documentation, but are still important and can still impact your ability to use the water or the value of what you're actually purchasing. Abandonment is something that can occur. Abandonment of a water right can occur by common law, through lawsuit, case law, or through the state engineer's decennial abandonment list. Every 10 years, the state issues a list of water rights that have either not been used, or that they believe have not been used, or maybe have partially been unused. And this is important because once that abandonment is confirmed, a portion of that water right essentially no longer exists. So you want to make sure that if you're under contract for 3 acre-feet of a specific water right, you want to make sure that there's still 3 acre-feet and that 2 haven't been abandoned previously, either through lawsuit or the state engineer's abandonment list. Adverse possession, I always go back at least 18 years for a title investigation that I am working on, just to eliminate any risk of adverse possession. And that is just, if someone else uses your water right or uses the water right for at least 18 years under certain circumstances, basically openly and known to the owner without their permission, then they can potentially gain legal ownership through adverse possession. So you want to make sure that water right is still, the water right still belongs to the person purporting to sell it and hasn't been adversely possessed by some other party. Expansion of use is something to look for. A lot of decrees for water rights in Colorado, irrigation rights specifically in the South Platte River Basin, were entered in the late 1800s. And when those decrees were entered by the water court, maybe there were only 65 acres being irrigated at that time. But over time, through increases in efficiency with infrastructure, new types of sprinkler technology, or extension of the ditch itself, the water right could potentially have been used on increased, expanded acreage, which is not actually legal under the decree. So you want to make sure whatever the current use is and the current irrigated acreage is actually legal under the original decree. I always want to check and see if there are any previous change cases for the water right. If there's been any kind of ditch-wide analysis or apportionment decreed, where maybe someone else wanted to change water rights in the same ditch. And so they looked at, okay, well, here's how much everyone in the ditch has allocated, per share in the ditch. You would want to know what that means for your seller or your buyer. If there are any prior change cases that have kind of odd rulings, a purchaser would want to know that because it potentially affects their future change case if that's the buyer's goal. And can potentially affect the value of the water rights also if they are restricted in some way from being changed in the future. You always want to look at your ditch company bylaws if your transaction involves ditch company stock. Sometimes the bylaws will restrict transfer of rights, transfer of the stock rights, or ability to file a change case. Many ditch companies now have Catlin bylaws. Those are pretty common now. It's basically the ditch company requires the owner of stock must have approval from the ditch company to change shares in that ditch company. And yeah, I won't get into the weeds on that. It's just important to look at the bylaws and see if there are any restrictions on transfers or conveyance of shares in the company. So when you're doing a title investigation, remember there's no title insurance. That's why we do this. As mentioned in the prior statute, ditch stock conveyances don't have to be recorded. They aren't going to show up in the title commitment. They won't be insured by the title policy. And as a water attorney, I don't want to be liable if my client ends up buying a water right that the seller didn't really own, especially in the current water climate, when water rights can make up a significant portion of the sales price. So I mentioned previously, I typically check title back to at least 18 years because that's the statute of limitations for adverse possession. Although I have worked on some larger, more expensive deals before where I've gone all the way back to land patent, like mid 1800s, and that is time consuming. just to make sure none of the water was ever deeded out of the chain. You want to know if there's any specialized case law. This is where the experience of a water attorney is very valuable. There's a whole series of case law on expansion of use, abandonment, adverse possession, change cases, and what the outcome means that it helps to be aware of when you're contemplating a purchase or sale for a client. If there is an existing title opinion, sometimes there is, especially for commercial and municipal purchases. If the buyer is buying from somebody that previously had a title opinion, you want to be sure and check the gap. And by that, I mean the time period from the date of the last title opinion to the present. Always verify ownership of the ditch stock with a ditch company. Most will not verify a chain of title, but they will usually verify current ownership. You want to make sure there's no missing stock certificates, and if there are, I've listed the statutes here to follow to get those replaced. Let's see, Kyle, are we close on time? How much time do we want to allow for questions?
I mean, we have 10 minutes left. There's really no hard stop. It's just, I know folks tend to schedule until 1, so they might drop off, but you're welcome to go past if it takes it.
Okay. Yeah, I might have to cut some of this a little bit short. So resources for title investigation. State water and real estate law. Colorado has the Water Rights Determination Act of 1969, which I think Jeff may have mentioned briefly. That determines how our water rights are administered and how water courts work. And a water attorney will be familiar with that body of law. And then most of you are probably familiar with the real estate title standards. If this, then that. If A files a quiet title suit, but during the suit sells the land to B, then after the sale gets a decree from the water court, does B still have marketable title? Yes. When we run into tricky title situations, we often look at the real estate title standards to see if there's a quick answer. We're always going to look at any water decrees or well permits. I think Jeff mentioned that also. Court documents or files affecting the property, like estate documents. Any encumbrances, lis pendens, mortgages, foreclosure sales. I always look at county land use and annexation requirements. And we talked about ditch company records already. Most title investigations are going to involve some sort of office document exam, like the abstract, O&E, or chain of title guarantee supplied by the title company. Or a record title exam, which is just looking at the deeds at the county, the grantor grantee records. Usually I end up doing some combination of all of that. Chain of title, I actually just do this in Excel. You sort of saw an example a couple of slides ago where I just create a text box and put all of the information for each deed in there and then chain it in chronological order. Title opinions. Okay, so your final product typically for a water attorney to provide on a conveyance is a written opinion. In writing, it's only for the benefit of your client. Always contains a very careful description of the water. I usually quote from the contract itself. It should provide a scope of work and documentation reviewed, and the name of the party with current title to the water. And then list any liens and encumbrances and recommendations for resolution and any disclaimers. For example, I always say in my title opinions, I'm not giving you any tax advice because I'm not a tax attorney. So you want to be sure and disclaim anything that you are not qualified to speak on. Let's see. Oh, and after you do all of this and you end up at the closing, let's see. What documents do you need for closing? Bill of sale, that's for any personal property. So wells, pumps, pipelines, irrigation hoses, ditch diversion structures or head gates, stock certificate transfers and assignments. Stock certificate transfers are usually executed and recorded by the parties, but given to the ditch company to actually affect the transfer. And then an assignment should usually be recorded with the county. The deed, the deed for the property and the water, if applicable, and I'll talk about a couple different types of deeds on the next slide. Any deeds of trust that apply to the water rights or to the land on which the water rights were used should be released at the closing. Oh, leases, any leases of water or farmland need to be assigned to a new purchaser if they are intended to continue. And any rights of way for third-party use. So access to wells or irrigation infrastructure. If you had a wellhead for a sprinkler or pipeline to a neighbor's property, you would need to transfer that to the new owner. Types of deeds, I think most of you probably know this. General warranty deed warrants title forever. Special warranty deed warrants title during seller's ownership. Quitclaim deed contains no warranties. Bargain and sale is similar to quitclaim, but does convey after acquired title. I typically recommend bargain and sale deed for the seller, special warranty deed for buyer, but you'll often see bargain and sale deeds or quitclaim deeds for water rights because very few people want to take on the liability of conveying something incorrectly, especially when we don't have great records for ditch rights. Specificity is key. I hate it when I see a deed that says any and all water rights because that really doesn't tell me very much. I always try to use the previous deeded language if it's good, or the language contained in the contract. And to the extent I have the information, I like to try to list exact shares or inches, decreed case numbers, pro rata portions of any augmentation plans, or any agreements, well permit numbers. And this is my second to last slide, actually. Okay, so considerations regarding other rights related to water. Check on any special districts, special water use areas like designated basins or Denver basin boundaries, which Jeff covered briefly. Let's see, got a story example here of that, but I'm not going to get into it. Yeah, there's a couple of examples here of risks, war stories about times that somebody did not check one of these and it kind of came back and was a problem in the end. Okay, so I think these things are obvious, but they come up so often that maybe they're not. Don't ever accept a seller's explanation or understanding of how their water rights work or have worked in the past. Always verify title to surface water rights, like ditch rights. Make sure you know what the residential supply is. I think on the past slide, I had an example of someone that found out a week before closing their residential supply was a rooftop cistern. And I always recommend parties to water transaction have independent representation and not a transaction broker. Okay, we are really close, so I'm going to go ahead and stop. Kyle, do we want to take questions now?
Yeah, that would be great if we can go ahead. I don't know if, I think all this stuff in the chat probably got spoken to, but if you guys see anything.
I'll mention that there was a point in the chat room, I think from Steve Myrick, about if there's a ditch across the property you're acquiring, even though you're not acquiring any water rights or any water interest, be aware that along with that ditch, there's an easement, and the company that operates that ditch uses it for delivery, or the downstream neighbors have a right to come onto your property to operate and maintain and clean the ditch, even if there's not a recorded easement.
Yes.
And I can't tell you how many disputes I've been involved in that deal with the rights of a adjacent landowner or a company to come onto somebody's property. So investigate it, talk to the company if you're acquiring land with a ditch across it. Thanks,
Thank you, Jeff. Thanks, Jeff.
And this is Kyle. I guess I would say also, if there's anyone who has to log off, or if anyone thinks of a question after the fact, you're more than welcome to send them to me, and I can make sure they get to the presenters for an answer. So I'm happy to do that.
There was one other question in the chat box about
Okay.
a rural land appraiser with experience in Weld County. I don't do land. We do water. Generally, I'll just mention a name, the go-to for water in this area among the appraisers you can do that is Kevin McCarty, who's out of Loveland, does a lot of land only, or excuse me, water only appraisals or water and land appraisals.
Well, excellent. I think there may be no further questions, so I'll say thank you to Jeff and Kara for presenting today, and thank you to Layla and Chad for helping get this set up. Again, I'll be sending out the written materials and the CLE form here shortly to all the attendees, and we do post the recording on our YouTube channel, so if there's anything you missed or want to revisit, that recording will be available. I'm going to have it up as soon as Friday afternoon.
Perfect. Thank you, Kyle.
Excellent.
Yeah, thanks everyone. It was really an informative presentation. Have a great rest of your day.
Thank you, everyone.